Introducing me. It's a lengthy
Indeed.
introduction. Thank you very much. Uh, of course, now you all are there as you introduce. This is a very important subject we are going to discuss. Very important topic, especially that since you all are involved in IT sector, not only the people who are involved in IT sector, even it's relevant to other people, all the citizens, even the international people on the earth. This is a developing subject. There are lots of controversies going on. We have to resolve a lot. So this is what we are going to discuss in the next uh, 1 hour and 25 minutes. But anyway, that I would like to agree with you. I hope that definitely you will agree with me. Uh, you have to ask more and more questions. This is the only way we can share our knowledge. Otherwise, I will deliver at the end of the day after 1.5 hours. You will get nothing. So when you have finished each submodule, even you don't need to meet. You don't need to wait until I finished the submodules. Even please raise your hand or please address me and ask if you have any questions. Okay. With that undertaking and with that agreement, okay, let's go ahead. What is privacy of a person? Now, you and I, as a human being, we must have basic privacy. Basic. Let's see what are this basic privacy. The privacy is also part of data protection. Sometimes we call this as privacy law, privacy policies, data protection policies like that. Now, when you say privacy, is a broad definition is there. But within privacy, that you can find some laws and regulations involved in that. That is the control of the personal data. Also, we call this as sensitive data. Controlling of personal data means not all data. Sometimes that some data available in the public domain. We are not going to discuss those data here. If you have very personal data, that means personal identification information in there. So we identify this as sensitive data. So that is where these privacy policies or these data protection laws involved. Now, what is the, let's see that what is privacy of person? Privacy applies on data that might be different for different people. Since privacy doesn't carry the same meaning of confidentiality. Now, you can see the confidentiality and the privacy are two different words. We will find some confidential secretaries, but we don't call them as privacy secretaries. So confidential secretaries means that they maintain secrets, business secrets sometimes in any organization. But here, this is not what now we are going to discuss. So that is why Samuel Warren and Louis Brandeis, who carried lots of research on this area, and for that they introduced this to the world when more than 100 years ago they wrote this concept to the world. They expressed their view in one of their articles titled "The Right to Privacy." So this is how they defined this privacy. An individual shall have full protection in person and in property is a principle as old as the common law. But it has been found necessary from time to time define anew the exact nature and extent of such protection. Now we can see jurisdiction to jurisdiction, we can see the differences of privacy policy. Era to era, also we can see such differences. Now take some example. The way you are wearing your clothes in a European country, for that you have no freedom, no privacy to wear the same manner in the Middle East country. Now you can see the jurisdiction. The jurisdiction, considering socio-economic, political, and cultural reasons, these privacy policies are different. Now take another example, era to era, how these privacy policies are. Now we don't know whether it's a true story or not. You can see the way that there's a way to wear clothes during Tinkashipa's time. So this is what we can see the Sigiri frescoes when we go to Sigiri. But today you can't wear like that. So once again, that you have lost that privacy. But once again, considering the requirement of the society. So this is what we say. Time to time, then period to period, or jurisdiction to jurisdiction. That application of privacy can be different. Now let's see that why these jurisdictions have enacted different level of privacy or sometimes data protection laws and policies. Can you see my third slide? Can you see the third slide? Topic of this plan. Yeah, okay, right. Okay, thank you. Now there are various reasons involved in this issue, mainly on political reasons. So due to political reasons, sometimes the privacy policies can be different.
Excuse me, sir. Sorry to interrupt, but your slides are visible, but it's not clear. I feel like you have a connection issue.
Okay, give me 1 second. I will change connection. Can you see the slide now?
Not yet. We can see the team's participants.
Now what's the situation? Still you can't see slides.
Yes, we can see.
Yes, we can see.
You can see, right?
We can see.
Because I think due to this bad weather, there's some connectivity issue is there.
Yeah.
Anyway, that's sorry. This is technology, right? Right. So these are the reasons involved in this issue. First is political reasons. Due to political reasons, the introduction of privacy policies can be changed. Now, take example in China. Now, China, that you can't use Yahoo account. You can't use Facebook account. When you don't have that privacy there. Because they have WeChat. So because they control their communication, because they are for some political reasons. But you can't see the same application in some other countries. But though we say some countries have given for that 100% freedom, even we can see there are some developed countries, the so-called democratic countries also, um, that the screen some transactions. They also intervene with some of the transactions. They monitor their transactions. Then next, considering the economic strength, also these privacy policies can be changed. Then continuation of traditional agriculture. Now take example. The country like Mongolia, still that they maintain their traditional agriculture. So they don't need to bother much about their privacy policies. Then development of industries and technology. Of countries who have developed in industries and technology, therefore they have to consider new concept to protect data protection or privacy policies as far as sensitive data is concerned. Especially if any nation or a region involved in international trade and commerce, they concern these privacy policies or data protection very high as far as the other situations are concerned. The involvement in international politics of the countries, this is also important. Or due to some international pressure, some governments are under obligation. They are forced to introduce uh, laws relevant to privacy policies or laws relevant to data protection. So you can see that various reasons involved in that. So that's why you can't find uniform set of privacy policies or uniform data protection law available to all jurisdictions in the world. Jurisdiction to jurisdiction, the situation is different. But all are human. All expect some uh, their data protection. All expect their privacy protection. But of course, that all jurisdictions they try their best to maintain minimum level of privacy policies. But when you look at laws, of course, jurisdiction is different. Under these circumstances, we have to harmonize and work on this new technology. It is not easy to give a guarantee of equal protection on privacy or data that can be uniform universally. Now, I hope that now you got the answer. Anyway, we can identify at least basic and minimum privacy protection that is relevant to any civilized society. This is what we are going to discuss. And in the classification of data into private and personal information that is labeled sensitive, that means very private, sensitive, is important as far as the level of privacy security relevant to data is concerned. Now let us see that what is this sensitive data? What do you mean by sensitive data? A civilized person on the earth feels that he or she must have certain individualism and reluctantly expose some information about him to the rest of the world. Now, if you asked me, what is your sexual behavior? What is my drinking habit? What is my eating habit? And sometimes, what is your religion? Sometimes that you don't feel, why should I tell my very personal reason? Now, especially today, if you asked from a Chinese person or even Japanese person or some living in that European country, if you ask them and ask, what is your religion? They won't answer. They don't answer. They have a religion, they have belief, but they don't like to tell what's the exact religion. Now, today is the situation in the EU countries. And if there's a job interview, when the interview comes before the interview panel, that interviewers can't ask the question that who is your father. What they say is, mother is there, child is there, is enough for their purpose. Unless there is some importance to find out what is the father's name. Now, take example, if they want to recruit people for armed forces or for their intelligence service, for their pedigree is very important for their country. as far as their national security is concerned. Then they might ask. Otherwise, if there is no relevancy to the particular employment job and there is no connection of the employment with the person's father, then you can't ask that question. So they have developed that up to that extent. Now you can see how this is developing, considering the requirement of the society. Remember, we are here up to this point. We discussed what is our individual, personal, the private data. What is in opposite? Citizens in a democratic country are entitled to find out certain information relevant to their lives. Sometimes we have to get some information. Sometimes it may be very personal information of another person. But to live in the society, live in a particular country, or live on the earth, sometimes the person wants to know what is the exact situation. Sometimes they want to know, the person want to know uh, some information. Otherwise, you can't live. Now, take example. Spreading of, say that we had that spreading of COVID pandemic. COVID pandemic. Of course, the virus, the person got virus attack. Of course, that is very personal. That is his. He might say that, why should I tell about my symptom to other people? Because you may feel that it's very private, it's a sensitive data. But when you look at the protection of the society, any person is entitled in that area to know whether there's a spreading of COVID pandemic in the area. So that is why even the health authorities disclosed and brought some lots of lockdowns to secure the entire society. This is the situation of spreading of virus. On that, I have taken other side of it. Now, if a person is HIV person, then like COVID, can the authorities also will come to know about this symptom, but can they inform others, the society, as a safety of the society? Can they disclose this very personal information to the rest of the world, to the society? You can't. Because unless you have this personal contacts with that patient, you won't get HIV. So that is very personal. Otherwise, if a people come to know that the person is a HIV person, then of course that person will be cornered in the society and various other consequences be there happen. To avoid that, even health authorities, they have a duty. They can't disclose this very personal information to the society. What's the difference between this COVID pandemic and HIV? Both virus attack. But when you look at COVID pandemic, that's an airborne disease. That, of course, health authorities give that information to society, saying that the so and so, that the person who got COVID virus in this house, therefore don't go closer to this place. It's isolated place. It's a quarantine place, or sometimes lockdown involved in that. But when you take HIV, situations are totally different. Right, I hope that you got the idea. So you have to balance this situation. While you are giving the protection for one's personal data or sensitive data, very personal identification information, the meantime you have to think about, you have to consider overall security protection of the society. So that is why we can see the right to information law also introduced to the world. How today the Sunday Times, the front page says IMF, International Monetary Fund, is seriously concerned about the implementation of right to information law in Sri Lanka. If we If we don't activate this RTI properly, then we won't get the facilities. So this is the alarm signal we get. Now, when you look at right to information law in Sri Lanka, we have Right to Information Act. So there are some items, subject matters, says that you can't apply this Right to Information Act on these subjects. Let's see what are these subjects. Causes serious harm to the defense of the state, its territorial integrity or national security. Now, you are not entitled to get information from the public authorities. And if you get this information, it may cause serious harm to the defense of the state or its territorial integrity or national security. Then this authority can refuse to give this information. Though it's a public information, they will say, no, we will not give this information because it comes under this first category. Secondly, like to be seriously prejudicial to Sri Lanka's relations with any state or international organization. Now, Sri Lanka has lots of other that connections with various countries. When you look at the international politics, we are also part of this the game of this international politics. So time to time, we also take some uh, actions. We support some countries, some regions to get a goodwill of the supporting country to maintain relationship with them. And not only countries, sometimes with some organizations. Then you can't get information about the reason to get this support, to get this information about the support the country gives to various organizations or countries. The next, exchange rates of the control of overseas exchange transactions, regulation of banking or credit. So you can't get this information. Taxation. This is another area because this is a controversial issue. As a citizens, that you and I, we are entitled to find out what is our fiscal policy of a country. You and I, we are entitled to know what is our foreign policy in this country as a citizen of the country. But considering taxation, but the reason to impose this taxation that you can't get this information. Stability, control and adjustment of prices of goods and services, rents and other costs, and rates of wages, salaries, and other income. You can find out what is the salary of one director that who are at the same level. Or if there are 5 directors, working directors are there in a government institution. One director can't find out as a right from the authority, what is the salary of that other director. Because to maintain efficiency and for the get the maximum contribution, sometimes the people might join with the same qualification. But considering their contribution efficiency, sometimes you have to introduce different payment, different pay policy. The next, borrowing of money by the government, entering into overseas trade agreements. This, of course, the dangerous. That is why sometimes people say this is not. We can't see any safety here because earlier, when the government wanted to enter into various bilateral agreements like ECA, the people came to know they got information or legally or illegally through various channels and they protested. But there are these countries going to enter into bilateral agreement. You can't get real the exact information of the current situation sometimes. Then trade secrets that harm the commercial interest of any person. Medical records related to any person. Prejudice to the prevention or detection of any crime or the apprehension of prosecution of offenders. Confidential information relating to law enforcement or national security. confidential information supplied to a public authority by a third party. So there's a long list. These are some few items I have highlighted here. No, this may be very recent. At the time of introducing this Right to Information Act, especially the media persons, they protested against this act. What they said was, this is of course not right to information. This is like denial of information. Because prior to this act, that media person, through their various channels, due to their personal contacts, they got this information. Sometimes, even after getting this information, there was no sentencing mechanism. There was no provision to fine or impose some punishment against a person who gave this information. But after introducing this Right to Information Act, considering these items, of course, that you can't get this information through the public bodies, maybe corporation, ministries, or other projects of government projects. Is it clear? Is it clear on this the situation on right to information? Are you okay with this? Are you okay with this right to information part?
Yeah, yes.
Okay, thank you. So when you look at this now, the data protection of privacy rights and the right to information, of course, this is a real battle. The real battle. It's the data protection of privacy rights versus right to information. It's like that two sides of same coin. Two sides of same coin. If any country has right to information law, in the meantime, they introduce data protection or privacy law. Unfortunately, in Sri Lanka, we introduced right to information law in 2016 due to some political promise, political reason, but not the data protection. There was no balance. So that is why we couldn't apply right to information law also properly. The later that our authorities also realized without having data protection, it is not easy to carry, especially online transactions, and it is not easy to enter into international trade and commerce. Due to this reason, now we also have brand new Personal Data Protection Act, Act number 9 of 2022 in Sri Lanka. If you take any democratic country, there shall be balanced process, formulating privacy and data protection law, ensuring security of a country while it is necessary to be a democratic nation. Democracy said that you are entitled to get information of others, the society, for your survival, for the safety of the society. In the meantime, people must have their own privacy. So this is a balancing process. If any civilized, any democratic country must balance these two situations. If any government or any region or any jurisdiction are capable to balance these two, only that we can see it's a successful country. It is a very democratic country in the world. Now, what is the situation? Now that information and communication technology is developing. Up to this point, of course, it's relevant to ICT and non-ICT both areas. Now, let's see, under the development of ICT, how that's right to information and privacy policies or data protection laws are important. This ICT is developing and privacy issues of personal data on internet users are equally increasing. When you look at the nature and behavior of electronic medium, especially the internet, we didn't have experience of this present issues prior to this internet era. It's a normally that people carry various information through print media or uh, through other TV channels or so like that. But when the electronic medium was introduced to the system, to the world, now we must understand that exact nature and behavior of this magic, magic medium, electronic medium. So when you consider the nature and behavior of this electronic medium, then you can see the day by day the increment of the requirement of the privacy of people, then importance of the right to information of people. Take example, using and misusing of private and personal data in social media platforms like Facebook. Now, when you look at Nielsen study, it reveals that Singapore has the highest frequency of internet access in the region, this region, with 80% of Singaporeans accessing the net daily. The latest ranking from Alexa show that Facebook is among the top 3 sites in Singapore in terms of internet traffic along with Google. I think, like Singapore, I don't think that someone has done the study in Sri Lanka. I can see that Sri Lanka second to Singapore. When you look at what happening in the society and reports, of course, we can see that we are also at the same level like Singapore. Development of technology has no territorial boundaries. However, governments have more concern to deal with such issues at local levels to give necessary protection, especially from data thieves. Though internet is borderless, expectation regarding privacy in different countries around the world is different. So this is what we discussed. Internet is borderless, but expectation regarding privacy in different countries around the world is different. This was discussed in Polly versus Fry and Sons case. It was decided that images of a person can convey to the outside the world. Polly versus Fry, what happened was the person gave some electronic image to one of their e-magazine. But then through this e-magazine, it distributed to the other jurisdiction. Then what happened was this lady complained to this magazine, say that, look, I gave you this image only to your publication. I didn't know that you will spread this image to the other jurisdictions. But court held that this is the nature of electronic media. You can't stop spreading the information to other areas. So knowing the nature and behavior of electronic medium, if you gave this image, that there's a reasonable person, your expectation from the person is that you have given authority to spread, distribute your items to the to not only the particular jurisdiction, to the other countries. It is the expectation of the customer to preserve his personal information given to the website vendor. Now there are various websites today that we are using websites. So they ask various questions before you enter into an agreement with them. So we must be carefully. Of course, now we have data protection law, but at the moment, this is not activated yet because the government has to set up data protection commission. With this personal data protection commission set up, of course, okay, we are safe. So be careful when you give information to various websites. When you feed your personal or very sensitive data to the screen, what is the guarantee that the collector or website person, we call them as e-tailer, you give protection to your sensitive data? So therefore, it is the duty of the website vendor to provide technical support necessary to assure the protection of data provided by the customer. Before you introduce me, that you explain this how this technology applies for this to maintain privacy, apply various type of security measures, transactions like encryption method, apply various encryption method, encapsulation method. Of course, you can give protection up to certain extent. Issue here is, can you provide this protection for your very personal information, only applying technology? Then if it is so, what is the best technology available to protect your personal data? One will say American system is the best. Another person can argue, say that no, Germany, there's a very good, very powerful method is there, that is the best. Another person can say, no, the Japanese system is the best. If there's a dispute arise about the duty of the collector, whether the data collector has given the proper security to personal data of data subject. Their subject means that if we take information from a person, say that if I collect personal information from you, you are data subject. Then if there's a dispute arise after collecting personal information, sensitive information from data subject, and if the collector failed to give the due protection, applying technology, say if there's a hacker or cracker attack, and if they have taken some data into their hand, then the data subject, the you, can go before courts and say the data collector has failed to protect my data. Then what is the defense that the data collector can do? He can say, I applied the best available technology to protect this personal data collected from data subject. Then data subject might argue, no, that is not the best system. It's available in other countries that you have applied, say, German system. So in America, it's better system is available. So then there's a conflict. If there is matter come before courts, of course, judge should be in the dark because he is not a technology person. He is not a scientist. So you can't decide whether data collector has applied the reasonably, the fair data protection mechanism to protect one's personal data. So therefore, it is the duty of any jurisdiction to provide legal solution as a supporting role, as giving the support to the technology. The jurisdiction must introduce a legal frame to give due protection for this personal data of their citizens. So it is the duty of the website vendor to provide technical support necessary to assure the protection of data provided by the customer. Now, this is a legal part is also involved in that. It's a duty of that person. We should respect the rights of individuals to decide for them whether they want private information communicated to others. If the collector intends to spread or share very personal information, sensitive data from data subject, then the data collector must get the permission of data subject to pass this message to another person, to distribute to the third person. If we receive certain information about unwanted drugs as a spam email, now how many spam emails we get every day? It will be a violation of all three kinds of privacy. That means they entered into our territory. First of all, they entered. So then they will interfere with our day-to-day life. Sometimes they take our information out. So collection of data using internet cookies without information. The user authority and phishing during transfer of data from one computer to another can be a collection of one sensitive data illegally. When you send messages from one device to another device, in between there are various the people, various mechanisms. Hackers are there, crackers are there, people who are involved in data theft are there. They use in various type of tools. They take this information, sometimes the personal information, sensitive information, into their hand. We call this as this offense as phishing. Now, tracking and distribution of information of a user deliberately to a third party during web browsing or surfing without his consent will disturb to his privacy. So that is why today we can see the various websites. They ask whether you agree with our or accept our privacy, our cookie policy. If you say yes, cookie policies, then you have to go through terms and conditions explained in the cookie policy. Or sometimes if you don't agree with their that cookie policies, because if they say we will share your personal information with others, then if you don't like that, you have to clearly express your view. Sometimes you may lose the site, can't help. Without asking from the data subject, the cookie can collect personal information into their hand to pass to their master. So data subject must aware that the cookies collect their personal data while they are involved in the particular website. Authentication systems, access control, applying cryptographic systems, data alteration every time when data is supplied to a site, cookies filtering, anonymization, and deal with only trusted parties are some precautions can be taken by a user with the support of technology to protect his privacy. Practical problem is how to declare the extent of technology support securing such personal data. The core issue here is how to decide the failure of website vendor to provide necessary technology support protecting personal data of the customer. This is what I discussed earlier. Now let's see the situation in the world, how these jurisdiction countries develop the mechanism to maintain this protection. Earlier in European region, of course, they impose time to time various directives. One directive is data protection, personal data protection directive, PDP directive. It was very powerful. Based on these directives, it's a duty of the member countries of that European Union, either to introduce new laws, or if they have they have their privacy policies or data protection law, and if it is not up to the level of this directive, then it's a duty of this member country to upgrade their and bring their laws to that level. So it's our obligation. Now take example based on that. Various countries introduce their own data protection laws. Now, after going through this personal data protection directive or laws, and considering the development of the technology, especially the ICT sector, European countries also realize this directive, the provisions under this directive also not enough. So as a result, they introduce General Data Protection Regulation. We call this as GDPR. GDPR, that EU 2016/679. It's a new EU regulation come into force on 25th of May 2018. It is not totally new law. we can see it's a one step ahead of Personal Data Protection Directive. The provisions on the GDPR replace step by step the Data Protection Directive. And this regulation is EU law on data protection and privacy for all individual citizens. We take example, UK. Now they left European Union, Brexit. Prior to Brexit, this GDPR came into operation. During that period, UK was also under obligation to that directive. Based on that, they introduced their data protection law. Though they are Brexit, they exit from EU, but still they carry the provisions under that data protection law enacted and introduced based on GDPR. It improved privacy and give greater control to customers and citizens over their personal information. It gives more concern over the data subject. It's given full option to data subject to control their own sensitive data, personal data. This is the idea of introducing GDPR. As far as Personal Data Protection Directive, we can see under GDPR, the more options, more powers given to data subjects who is the owner of this sensitive data or personal data to control their own this sensitive or personal data. This directive, these regulations apply to European Union plus the European Economic Area. Now there is a question arise: is the privacy a law or policy of the country? So it's a law or a policy. A breach of a legal duty to take care by the defendant causing consequential loss to the claimant can be tort of negligence. This comes under tort of law. Traditional division of negligence into its constituents is duty, breach, and damage. It's for convenience. This is what we learn under law of tort. A more recent trend has been restricting the scope of liability in relation to certain well-defined types of non-physical harm, notably economic loss and psychiatric damage. This is one concept under law of tort. But take example Sri Lanka, our common law is Roman Dutch law. So as a result, there are some concepts under the law of dealings. Of course, nervous shock and various other concepts are there. Other than that, still, you can't claim damages for your psychiatric damage, mental damage. When people come to us due to various reasons, and they're asking, of course, as a result of behavior of so and so, and due to this motor traffic accident or some other action taken by other defendant, I undergo the various mental pressure and depression and various things. But you can't claim damages on that. What we do is we convert this psychiatric damage or mental damage into physical damage. As a result of this, of course, this causes the physical damage to this much. Then you can claim this amount as compensation for physical damage. So this is the situation at the moment in Sri Lanka. But anyway, we can see now our legal system is also that under modernization, with modified with various provisions, judgments. Anyway, that in future, of course, we have to think about this matter very seriously, and sometimes we have to change our concept as well as far as development of ICT sector is concerned. Now let's see how some jurisdiction in the world they applied this concept. I told you earlier, jurisdiction to jurisdiction, application of data protection or the privacy policies are different. Now, this is the situation in the United Kingdom, an English legal system, English courts. English court reluctant to lay down new rules of common law or equity on privacy policies, since it is the duty of the legislature. If there is no that privacy policy is introduced through the parliament, court will not introduce that new laws to the system, the society. Well, what this English court says, it is not the duty of the English the judicial mechanism. It is not the duty of the court to introduce new laws. It is the duty of the parliament, legislature. These are discussed in various judgments, and tort law by Kurtzi Horsey explained at page 446, quoting the particular judgment made by House of Lords in Wainwright versus Home Office, that English law contains no specific privacy right and does not need to create one. Lord Hoffman indicated at page 18 of the same judgment that English law has been unwilling and might even be unable to create such a tort. In Campbell versus Mirror Group newspaper case, Baroness Hill has stated that our law cannot, even if it wanted to, develop a general tort of invasion of privacy. Then both the judiciary and parliament have a history of reluctance when it comes to the creation of a tort protecting privacy. There are many possible reasons suggested for this, including a lack of precedent, lack of suitable definition of privacy, and the impact of restraint being placed on freedom of expression. The United Kingdom, they consider freedom of expression at the highest level. At the highest level, what they say is, if it's a democratic country, you must have freedom of expression, unlimited. Under this situation, neither judiciary nor parliament like to create a tort protecting privacy of people. So there is no absolute privacy or data protection rights granted to people in a country like the United Kingdom, and these rights are vested subject to various conditions considered safeguarding the entire community. So that means no absolute privacy. In Kai versus Robertson and Sports Newspapers Limited case, it was recognized the need for the creation of a tort of invasion of privacy. For the first time, in this judgment, the court realized, it was recognized and realized that country needs for a creation of a tort of invasion of privacy. Let's see what the situation in France under French law. With a very narrow gap, very clear that only 24 to 30 kilometers between UK and France. This is a neighbor country, closest country to UK. But as far as data protection law or privacy policies are concerned, we can see the opposite of English law. French law strongly protects privacy rights, and invasion of privacy is a crime, and therefore people, including celebrities, have traditionally been able to keep their private lives very private indeed. Now, this is a situation in France. As a result, what happened? This was reported in the news item of Straits Times, 19th of September 2012. It was reported the French court has banned a gossip magazine from further publishing topless photographs of the wife of Britain, Prince William, the former Kate Middleton, and ordered it to hand over the pictures to the royal couple. What happened is when they were holding on the beach of France, some paparazzi people, they took some photographs and published in a magazine. Their public litigation mechanism is very, very powerful there. They brought this matter because they felt that it's an insult to their country. The court immediately ordered to collect all magazines they sold and destroy, hand over everything back to this royal couple and impose heavy fine compensation against the magazine. Now, similar matter was brought before UK courts, London court. But UK court said no. Freedom of expression. Royal couple from UK got heavy compensation from France, but not from UK. Now let's see what the situation in our neighbor country, India. In India, right to privacy is implicit from constitutional right. However, it is restricted only on the basis compelling public interest. This was discussed in the Puthusami's case. Puthusami's case, the Supreme Court recognized it is a fundamental right of a people of the country, and they are entitled to maintain the protect their privacy. Privacy protection is a fundamental right in India. This was discussed in Puttasamy versus the Union of India. Puttasamy versus Union of India case. Now, this is subject to the protection of safety of the society. That is how they balance the situation. In People's Union for Civil Liberties versus Union of India case, it was decided that disclosure of information relating to the criminal record of a candidate contesting an election did not violate the candidate's rights to privacy. It was further held that individual right must be subordinated to the right to information of citizens where there is a conflict between these two rights. So they consider this person is a public figure. To consider to vote in favor of this person or not, that voters have right to know about this person. So therefore, publication of or disclosing various information related to criminal record of this person, candidate, is not a violation of privacy law. This is what decided in this case. In People's Union for Civil Liberties versus Union of India case, it was held that right to privacy is subservient to that of the security of the state. When in Sharda versus Dharmapas case, balancing test between the right to privacy against disclosure of information and the right to lead a healthy life was applied. In Doraisami's case, once again, the one newspaper published the candidate of the election. They disclosed about this financial records of the candidate. The candidate filed a case saying that this particular newspaper violated his privacy. Court held that no, he's a public figure. Considering the safety of the society, the voter must know his financial situation before they vote. So otherwise, if they hide these financial records, it's already happened in Sri Lanka. We have a very bad experience here. After becoming to various positions, they can play misuse that country's money. So then there is no transparency. So avoid that we need some mechanism. This is what that judges said in Doraisami's case. Doraisami case, publication of financial record of this public figure is not a violation of privacy. Now, when you look at data protection laws or privacy policies in various other jurisdictions, we can see Article 17 of the International Covenant on Civil and Political Rights, we call this as famous ICCPR Act, states no one shall be subject to arbitrary and unlawful interference with privacy. Now, based on this, we also brought an amendment to Article 14. Now, we have Article 14A under our Constitution. It explains right to information. Within that right to information clause, it says that you can't get this information about the individual's personal data. So we can see some safety of personal data under our Constitution. But anyway, they are addressed mainly on right to information. Under that, we can see we have addressed personal information, personal data as well. Now, Organization for Economic Cooperation and Development, OECD, in EU countries, issued a set of guidelines for the protection of privacy and trans-border flows of personal data as a model in 1980. As far as, once again, considering the nature and behavior of electronic medium, the internet, every time we have to expect cross-border issues. You can't keep data within one particular territories of a jurisdiction. No territorial jurisdiction involved in cyberspace. It's a global village. the cyberspace. So transborder flows of personal data are very, very important. Then there's a serious question arises. How to maintain, how to control transborder flows of personal data under circumstances under uh, different jurisdiction apply different laws under this situation. How to balance this? In the European Union, the directives are legislative instruments for member countries, and they can enact their own statutes within the framework of the state. As a result, we can see EU Directive on Protection 95/46 European EC. The European Parliament introduced this harmonizing of existing data protection law already available in member countries and introducing data protection laws for other member states who don't have the same. This is what we discussed earlier. Further, the set directive provides provisions securing data when transfer them to outside EU or to non-member countries according to Article 25. A simple definition, a simple mechanism is what these EU countries, what they say is, if they, before they send that personal data or that sensitive data from EU country to a non-EU country, so the privacy, the commissioner must give permission for that. They will look into that matter whether the receiving end, the receiving country maintain acceptable privacy policies or data protection law as far as the standards of EU countries are concerned. If this non-EU country maintain such laws or policies in that country, only EU countries will send very sensitive data of people to that country. European Commission adopted the Directive on Privacy and Electronic Communication, mainly focusing online privacy, because after considering that earlier introducing that the data protection, that directive, they maintain their privacy policies up to a certain extent. But considering the development of ICT sector and online transaction, they realize the provisions under that directive is not enough. As a result, they introduced Directive on Privacy and Electronic Communication, the Directive 2002/58/EC. So, Privacy and Electronic Communication Directive deals with confidentiality of information, treatment of traffic data, spam, and cookies. So that is how we get this new cookie policies. This directive has been amended by Directive 2009/136, introducing several changes, especially in what concerns cookies that are now subject to prior consent. So as a result, again, once again, we discussed this slide that GDPR is in operation. Let's see what is this GDPR. General Data Protection Regulation set out 7 principles for the lawful processing of personal data. These 7 principles are very important because as far as provisions under our brand new Personal Data Protection Act concerned, we have hired these 7 principles into our act in a different format, right? Not the same format, different format, but still we can see the same 7 principles are involved in our act. Let's see. First of all, we must know what is processing. What is the lawful processing of personal data? Processing includes the collection, organization, structuring, storage, alteration, consultation, use, communication, combination, restriction, erasure, or destruction of personal data. You see what's the item omitted? Everything is there. Am I correct? Processing includes everything. If this is processing on the personal data, then you have to follow these 7 principles. Let's see what is first principle. Lawfulness, fairness, and transparency. When the data controller collects sensitive data or private data, very personal data from a person, it must be lawful. Collector must explain to the data subject for what the reason he collects this data, whether it's lawful. Then even the data subjects will be in a position to understand it's fair to collect this data. Otherwise, this data collector can't provide some service. Or there must be transparency. What the type of information they collect for the purpose. Then come to second principle, purpose limitation. They must collect data only for the purpose. Now take example. Go back to the same example I explained to you earlier. If a person comes for a job interview, so say it's a cleaning job, say it's a cleaning job. Then what is the purpose asking about his father? Even the mother? No reason to ask that question. Then the interview also must limit their questioning, collecting data from the person, because it's a purpose limitation. Then third principle is data minimization. Of course, sometimes by mistake or purposely, data collector collect additional data from a person. But anyway, it's a duty of the data collector to maintain minimum data for the purpose, or delete additional data collected, or return data to the data subject. We call this principle as data minimization. Then next is accuracy. If I collect your personal data, sensitive data from you, then it is my duty to maintain accuracy of your personal data. After collecting your data, I can't keep them, I can't process this data, tarnishing your good name, damaging your person character. I have to maintain accuracy of your personal data. Then the storage limitation. Now take example. If say this year my virus card is not an antivirus, I have signed the contract till say 1st of October 2024. Now during this period, not an antivirus people will ask various questions. Sometimes they will get my personal information also into their hand. But I will decide on 1st of October 2024. I will stop my licensing with not antivirus. After 1st of October 2024, I am going to Kaspersky. Now, up to 1st of October 2024, these not antivirus people will collect my sensitive data for the purpose of providing the good service to my system. But anyway, there is no more license, no more agreement with me by this not antivirus people. So after 1st of October, not antivirus has nothing to do with me. So it is the duty of the not antivirus to hand over all sensitive data collected from me, because they have concluded the license, this that's a security contract. We call their storage limitation. Then the sixth principle is integrity and confidentiality. That means it is the duty of the data collector to provide security, maintaining integrity and confidentiality. That means it is the duty of the data collector to provide cyber security for personal data or sensitive data collected from data subject. The final policy principle is there must be accountability. At any time, data subject is in a position to inquire about his or her personal data, sensitive data collected by data collector. And if the data subject need, he can withdraw the consent given to the data collector to keep or collect personal data. Data subject can ask him to remove particular data, modify particular data. Now, these are the 7 principles under General Data Protection Regulation. We call these as 7 principles under GDPR. Okay? Are you okay with the 7 principles? Do you have any doubt? Do you have anything to be clarified? Are you okay with this?
Yes, sir.
Okay, all right.
Yeah.
Keep in mind these 7 principles. Keep in my mind these 7 principles only that you must read our act. Then only you can understand. Some countries, the GDPR considered as fundamental rights, especially some European countries. But in addition to this, of course, in countries like United Kingdom, they have various acts, other acts, Wireless Telegraphy Act, Telecommunication Act, and recently they have Data Protection Act 2018. In United States, there is no separate privacy protection law there. Anyway, various acts provides due protection for data. To prevent an imminent information embargo, the United States Department of Commerce created safe harbor principles on 1st of November 2000, addressing privacy concerns of the EU relative to US laws and commercial practices. US is not a member country of EU, but US main export market is in EU region. So if the United States is not ready to accept privacy policies or data protection law available in EU, then US will lose their export market. To avoid that, what they did was they went for safe harboring system. That means voluntarily they accepted this EU privacy policy. In addition to that, we can see we can find online privacy protection at OPA. Even for as far as children are concerned, we can see Children Online Privacy Protection Act as well. We call this as COPA. As far as this data protection of privacy policy is concerned, the Jutnik versus double click, this judgment is very important. There, what happened was Jutnik gave some information to software, the website called DoubleClick, a direct marketing service company, which maintained a database about the purchasing patterns of most American households, acquired private personal information without the knowing consent of internet users. The plaintiff, Helen Jutnik, instituted proceedings against the online marketer of illegally collecting and selling consumers' private personal information and claimed that DoubleClick violated her privacy rights when it combined with personal identification information, PII, with cookie data. Shortly after the suit was filed, DoubleClick announced that it would no longer continue its practice of combining personal identification information and cookie data. Anyway, use of cookies by United States websites and online service providers that do not combine cookie data with personal identification information is routine and apparently legal, even though users are not notified nor is consent obtained. This is one exception for this data protection. If any person use this personal data for the purpose of household or the personal transaction, then it is not a violation of data protection. This is an exception to data protection law. Anyway, when you look at our act, also we can find this exception. In Australia, also you can see data privacy is governed at the federal level by the Privacy Act of 1988. As far as privacy laws are concerned, New Zealand, Australia, and Hong Kong, they maintain the highest level of the privacy policies or data protection there. Even it's more powerful than EU GDPR. This is new because in New Zealand and Hong Kong, they have introduced privacy commissioner mechanism. The privacy commissioner role of the privacy commissioner is very, very powerful there. Even India is currently facing many problems, resentments due to absence of proper legislative framework there. Anyway, recently an exercise of the rule making power conferred by Section 87.2 read with Section 43A of the Information Technology Act 2000. The central government promulgated the information technology, we call this as a reasonable security practices and procedures and sensitive personal data of information rules 2011. Introducing these rules, they cover this personal data protection. These rules address the obligation of the corporate who collect the sensitive personal data of an individual, the obligation being those pertaining to its use and disclosure, right of the information of the provider, like that they have given these conditions there. So in India recognized privacy policies under the Constitution. I have already explained you there in the government and the judgment also Puttaswamy versus Union of India's case. Now let's see what the situation in Sri Lanka. What is the legal protection available? Now, in addition to this Personal Data Protection Act, number 9 of 2022, we can see some sections covered this personal data protection up to a certain level, especially when you look at Section 10 of Computer Crime Act. It's explained how our legislature has introduced the protection of personal data as far as computer crime is concerned. The legal protection given if information of users collected by the service provider, especially enabling the users to access their services provided by means of computer. Though there is no separate statute on data protection or privacy enacted in Sri Lanka at that time, even from 2007, it is the duty of the collector to keep this sensitive data as secret data. Violation of this provision is a computer crime and punishable under Section 10 of Computer Crime Act. So Section 19 of the Computer Crime Act, once again, has empowered the investigators under the Act to give directions to responsible peoples to preserve such data for a period specified in the same order. So now we can see we have introduced this brand new Act, number 9 of 2022. Let's see the structure quickly about our Personal Data Protection Act. It's introduced regulation of processing of data, personal data, to identify and strengthen the rights of data subjects, providing for the designation of the Data Protection Authority, to regulate the dissemination of unsolicited messages using personal data, and further to provide for matters connected to the same. These are the main objectives of this Act. This law has been specially introduced to facilitate the growth and innovation in the digital economy of the country, whilst protecting individuals' rights and ensuring the consumer trust in information privacy in online transaction and information network. So there we can see as far as these objectives are concerned, based on that, we have that our legislature has structured this act. When you look at Section 2, application of Section 2 is very important, applied to the processing of personal data. Processing takes place wholly or partly within Sri Lanka. That means happened in Sri Lanka or outside Sri Lanka. This act is applied. Processing of personal data is carried out by a controller or processor who is domiciled or ordinary resident in Sri Lanka, is incorporated or established under any written law of Sri Lanka, offers goods or services to data subjects in Sri Lanka, specifically monitors the behavior of data subjects in Sri Lanka. Anyway, there's a very important part is there. Now, get this document, Judnik versus double clicks matter. Now, this act, according to this Section 2, the act has no application to any personal data processed purely for personal, domestic, or household purposes by an individual, and any data other than personal data. So this is what happened in Judnik versus double click case. So this concept we have introduced to our act as well. Then we can see some 6 schedules under our act. And GDPR, there are no such schedules there. Black and white, they explain what are the conditions. But here, of course, we can see that they have divided certain items. Requirement, the level of protection requirement to maintain some data protection that we have introduced 5 schedules. Conditions are different as far as these items under these schedules are concerned. Now, the part 1 of the act explains the obligation of personal data processing by a data controller. Their section 5 is important. It's obligation of the controller to ensure processing of personal data as specified, explicit, and legitimate purpose, and shall not be further processed incompatible with the same purpose. That means they are following the that principles we discussed under GDPR. Section 6 explains obligation to define the purpose for personal data processing. Likewise, we can see up to Section 12, up to accountability, because basically all principles under GDPR introduced to our Act. Or subject to the written law of Sri Lanka, offers goods or services to data subjects in Sri Lanka and monitors the behavior of data subjects in Sri Lanka. The right of data subject explained starting from Section 13 to Section 19. Controllers and processes, they explained from Section 20 to Section 26. So there's a part 5 explained data protection authority. How they are the authority to look into the violation of the violation of data protection law. And the penalties are introduced here under part 7. So this is the operation of our personal data protection net. Please go through the provisions. Once again, I have to make a request. Keep in mind the 7 principles we discussed under General Data Protection Regulation in EU. Then you can find that we have hired these 7 principles under our Act as well. Still that we can see some loopholes also under our Act, especially as far as the transport data is concerned. Of course, that we have to bring some provisions strengthening this Act. Anyway, first of all, we have to, at least now we have the piece of legislation, because we didn't have the piece of legislation earlier. So now, after application, this of course we can think about future amendment. Now, as far as data protection privacy policies are concerned, cloud computing, we can see the complicated issues involved in that, because everything is cloud. Then who is going to look after the security for the personal data in cloud? Once again, when you look at this, that principle, 7 principles under GDPR or provisions under our personal data protection, that we can see, we can apply the same principles, subject to some modifications to cloud computing as well. These are the 3 principles applied for personal data processing: transparency, lawful basis for processing, purpose limitation, and retention. So in conclusion, I have to say, are we capable enough to step into international trade and commerce via electronic commerce? What is the extent of rights provided to an investigator to obtain sensitive data of people maintained by various private or public institutions, websites, e-commerce vendors, etc., for the purpose of criminal investigation or internal investigation? Can we invite international investors to invest in our country if we don't have very powerful data protection law available in the country? So with that, of course, I can conclude my presentation. Anyway,
Yeah.
that you are welcome to share your views. And if you have any question, please ask. If there is any gray area to identify, or if you feel that I have not addressed some area because you couldn't understand properly, please ask. It's up to you. What's the situation? Are you okay with this explanation of data protection law? Do you have anything to clarify? Yes? Yes, Hiroshan? Vijay Surya? Akil? Yeah. There's a bit here. Dasul? Yeah. What's the situation?
Hello, sir.
Yes?
Yes, sir. So earlier you mentioned that there are some certain countries have because of economic and cultural backgrounds, there are like restrictions, like as in there are like the data protection laws are not the same, right?
Yeah.
So what's stopping other like multinational companies from like abusing those sort of like those countries? And other than the reputation of the country, so like are there international bodies, as far as I know, there are no international bodies in the UN regarding data protection. So what's stopping those things from happening?
That depends once again on that your power of any country. That's a, can you remember the reasons to introduce data protection. That one reason is their political power. Any jurisdiction, any country will introduce their own laws based on socio-economic, political, and cultural reasons. Now take example, country like China. China, we can see lots of restrictions as far as data protection, no, that other the freedom they're available in countries like United States or some European countries. But anyway, can we impose restrictions on China? Recently, that's a very powerful country. What they say is there must be restrictions or some limitations for that. Otherwise, they can't run the country. Now, what they say is giving too much of democracy also can be trouble issue to their country. Anyway, with these conditions, Chinese communities are happy. We don't know exactly they're happy or not. Anyway, what seems is happy. Now, country to country, this situation, but only mechanism is to maintain safe harbor system. Safe harbor system means voluntarily they will accept privacy policies or data protection available in another country, their trade partner. So they will accept the situation of the country if their trade partner voluntarily. This is what US and EU, what they do. United States is not a member of EU country, EU region, but US also maintain the same that their directives available in UK. Otherwise, they will lose market. This is the only solution. As you said, there is no international treaty or convention as far as this is concerned. But anyway, when you look at Budapest Convention imposed restrictions, mandatory provisions to member countries to maintain data protection law. Now, Sri Lanka and Singapore, we are members, and even in Japan, we are the three members from Asia to Budapest Convention. So we have international obligation to maintain that part as well. Anyway, now we have Data Protection Act now. Is it clear, or are you okay with my answer, or do you want to get more information about the situation?
Yes, sir, the answer is okay.
What about others, please? Sahani? Shiraz? Katum? You okay? Anyway, if I ask one question, when you travel by public transport, inside a train or bus, or even if you go to some park, can you get a photograph capturing some young couple or some other people into your photograph? You are taking photograph, but your purpose is different. You can see some young couple, they behave, or they are freely they behave, but you want to capture their picture. That is why you are taking this photograph. Can you do that? Yeah. This also comes under processing. To take processing, they are given a very wide interpretation. Capturing is also come under processing. Now, what is the situation? Can you get this photograph? Especially if you go to South Korea, Japan, even EU countries or China, be careful. You know, take photograph that who are behind background, who are in the background. If the person come to know that they took their photograph by you, that they can demand and they will ask you to show the picture you got. Then they can demand you to erase, delete that particular item. But here, of course, if you are not strong enough, of course, then of course you have to delete. If you are strong, you would have keep it. But now after introducing this Data Protection Act, now situation is different. You can't. Be careful now. because our data protection, personal data protection act is in operation now. So that is why countries like United Kingdom, France, Germany, they have set up their CCTV cameras on streets. But anyway, before when you walk on street, you can see the CCTV camera is in operation 50 meters ahead or 100 meters ahead. So they have to give that information. They can't just capture your movements. Say if there's a young couple is walking on the street, after seeing this, of course, they will separate and walk. So they have to give the information. Otherwise, they can't collect this information they are had, even by the state. But in what's the situation in Sri Lanka? Have you seen this? Few places I have seen, not in common. Even police also detect some people. They are hiding somewhere, and right? They can't just come out and detect. No, that is wrong. If you capture something to your CCTV camera system, it's also losing your privacy. Then you must inform the general public. The CCTV camera is in operation. This was a requirement under this law. Okay. Right. What's the situation? Akil, are you okay that you invited me, that you and that they invited me to make this presentation? I hope that briefly that I gave all required contents. This subject of we can discuss days and days or even weeks because it's not enough. There are various practical issues involved in various countries. Anyway, this area is developing in all countries in the world. And now Sri Lanka also became one of the members there. We also have developed a lot. We have to go a long journey to enter into international trade and commerce, the international market successfully. All right, if you don't have any questions, we can leave. Otherwise, if you want to ask something, I can wait. Silent, give silence.
Since there aren't any questions, we can proceed to our conclusion.
Yes, yeah.
So thank you, sir, for the enlightening session on data privacy and for sharing your profound insights and expertise with us. And thank you for the esteemed participants, distinguished and our dedicated audience for joining us today, and your active participation has made this session all more valuable, and we look forward to hosting more engaging sessions in the future. So stay tuned, and until then, please take the knowledge you've gained today and continue to champion data privacy in all your digital endeavors. Thank you and have a wonderful day.
Thank you.
Thank you, sir.